Florida.
Thank you, Mr. Chairman, and thank you to all of our witnesses who are here today. We so appreciate your time and your testimony helping inform us about how we might embrace the emerging technology of artificial intelligence, but also recognize the immeasurable value of our artists and the need to protect and balance intellectual property and copyright protections. I'd like to return, Mr. Damley, to your testimony, and specifically during the questions by Congressman Moran and Frye, you talked a bit about your perception that existing copyright law was adequate to take on this new emerging landscape and continue to resolve that balancing between the property rights of artists and our new technology that we see. One thing that concerns me is that when Congress fails to be sufficiently clear, we leave to judges the task of figuring it out. And of course, we want judges applying the law, not creating it. We don't want to put judges in the role of being policymakers. So I would like for you to elaborate a little bit more on your conclusion that our existing statutory framework is sufficient to take on this new challenge.
Thank you, Congresswoman. It's an excellent question. I think if you just look at history here, fair use has existed in the copyright law for about almost 200 years. And over that time, it's dealt with lots of massive shifts in technology. 1984, the Supreme Court applied fair use to the then new technology of VCRs and said, applying, again, a 180-year-old law that did not have any understanding of that kind of recording technology, and made a really fact-bound, cautious, careful decision about whether home recording was fair use or not. Fast forward through the era, recently the Supreme Court handled a case involving software APIs. Again, something no one could have ever dreamed of as being a copyright issue 180 years ago. Yet the court, again, looking at the very specific facts of that case, determined that the reuse of software APIs was fair use. And there have been other cases going the other way, looking at new technologies like Napster and saying, that is not fair use, that's an exploitive use of the technology. And so my perspective comes from looking at that long history and how copyright law has been able to manage shifts, even major shifts in technology.
And Professor Birch, what's your take on that same question and the conundrum of not over-regulating, but at the same time, not leaving it to courts to try to create policy?
I think that it's worth considering all these issues and deciding whether or not copyright needs to be extended. I think that there's many things that my fellow panelists are talking about that are 100% valid and need to be incorporated into the ethical guidelines that AI system developers create, including right of publicity and copyrighted characters and things like that. And those are not currently covered sufficiently by copyright law. They may be covered by other laws sufficiently, but I think that's where the target should be. Like, what is the output of these systems and what is correct use and incorrect use of the output of these systems?
And Mr. Navarro, one of the advantages about getting to ask questions near the end is that I can bring to you this one. Is there anything that you wanted to share with the committee today that you have not to this point in the hearing been asked?
That's a good question. First of all, when we look at the ingestion of trillions of pieces of data, that's one way of looking at it. But when we look at the impersonation of voices, that's really one piece of data. And that's very specific. And it's easy to get lost in the shift between the macro and the micro as we figure out where to go on this. I think we need to take a look at both. I think the other is that I appreciate the technology, I appreciate the technical use of terms, but my music isn't data.
And Mr. Irwin, the same question to you. Anything you wish to share with us today that you haven't already testified to?
I'm going to follow on what Dan said. I'm a little distressed that we're calling this training, to be honest, because in my mind, we train athletes or animals. We don't train machines. We equip machines with data, as the technology people like to call it, but as we like to call it, music. It's very Orwellian how the tech industry manages to change terminology on us. It's not data and content to us, it's music, it's photographs. It's not file sharing, it's stealing. It's very simple. They're the sort of things I wanted to get into the record that I didn't get to say.
Thank you. Mr. Chairman, I yield back.
A brilliant move for such a new member.